Io darei adesso la parola a uno dei nostri ospiti venuti da fuori Italia, se è d'accordo, Alex Tinsley di Fair Trials International, che può illustrarci il rapporto preparato dalla sua organizzazione.
Thank you. I'm going to speak in English. I hope that's okay. First of all, I want to apologize because I'd prepared a presentation on PowerPoint, so I'm going to have my computer out in front of me here. I'm sorry if that creates a barrier between us. So just while I'm loading this up, about who we are, Fair Trials International, we're a charity that's been in existence for 20 years odd. We assist people who are detained all over the world. We put them in touch with lawyers and help them navigate their way around unfamiliar justice systems. And in recent years, we're becoming more and more involved in this area of work relating to Interpol, culminating in the publication of a report just recently. The background to our involvement in Interpol comes from a case called Benny Wenda. He's an Indonesian refugee in the United Kingdom, the leader of the movement for the independence of West Papua, which is a province of Indonesia. And he came to us when he found himself on the Interpol wanted list with his photograph. Oh yeah, brilliant. So there you have it. That's Benny. The photo at the bottom is a screen grab of the red notice concerning Benny Wenda. The photo that you see on the red notice was actually taken from his own campaign website. And we saw that as quite a worrying thing at the time because it showed that the Indonesian authorities were using this system in a political way. They were actually using the legitimacy of the red notice to undermine the credentials of a campaigner who was working against them. So that really raised our concerns about Interpol. Then in the last, sorry, I just need to kill this. In the last year or so, we've been assisting this guy, Petr Silayev, someone who participated in a demonstration in Moscow in 2010 against the new St. Petersburg-Moscow motorway, which goes through the Khimki forest outside Moscow. And when lots of activists started being arrested, he fled the country, was swiftly granted asylum in Finland, which knew full well that he was being prosecuted, didn't exclude him from asylum, but just welcomed him as a political activist. Nevertheless, he was arrested short time after in Spain, based on an Interpol diffusion, which is very similar to a red notice, and all the issues concerning red notices are the same. Based on this charge of hooliganism, the offence that Pussy Riot were accused of, that the Arctic 30 activists have recently been charged with. So really concerning case. And again, as we've heard, the Spanish court in this case refused extradition, but Interpol nevertheless considered that it could maintain this alert on its system. So that's really, those are the two main cases that we've been really raising concerns about. In parallel to all of this, we've been having discussions with Interpol. We met with them quite early on in the campaign in June 2012 and discussed what at the time were our major concerns and found out some information quite superficial at that stage. We also wrote them some letters asking about 60 questions in total. Originally, we weren't given any information in response. But we were given a bit of information from the Commission for the Control of Files, which is the body that individuals can apply to to challenge Interpol red notices. And then recently, we shared a draft of the report that we've just published with them, and let them comment on it, provide corrections of factual inaccuracies, and to hear their views on the recommendations. And we took them on board, reflected some, and didn't reflect others, and just recently published this report called "Strengthening Respect for Human Rights: Strengthening Interpol," which is available on our website. I emphasise the word "strengthening" because for us, it is about protecting Interpol from abuse, We're not here to say that Interpol is an inherently, a bad organisation. It's a very useful one, and it helps police forces legitimately seeking to tackle criminal, serious organised crime, to do a good job. But the problem is it's being abused by some countries. So for us, it's about strengthening Interpol against those abuses. So in our report, really, we begin by setting out the main impact of a red notice, because all of this matters, because when you're subject to a red notice, your life suffers. We've just heard about the case of Bahar Kim Jong-un, who is indeed still detained. He has a bail hearing tomorrow morning, I think. He's being assisted by members of Fair Trials International's legal expert advisory panel in Belgium, Spain, and Italy, and we're very much looking forward to doing further work on that case. So arrest is the obvious impact, but you also have things like people losing their jobs. We assisted someone who worked on transatlantic flights for a UK airline, and suddenly found herself with no job because her US visa, which she needed for work, was removed by the US authorities because she had a red notice, and it was based on a bounced check offence in a Middle Eastern country, which obviously isn't a criminal offence anywhere else in the world. Restricted freedom of movement is another of the major effects. People find themselves stuck in one country for a year because they don't want to risk being arrested 5 times. Mr. Kim Jong-un is the exception, because he has no fear of being arrested and will keep travelling as much as is necessary to do his job, but that's pretty rare. Usually people simply accept it as an awkward fact of life and keep themselves to one country, or perhaps the European Union. And obviously being subject to a red notice can have a disastrous effect on your reputation, particularly if you need credibility for your line of work, business or journalism, for instance. Because it has such a bad impact, you need good rules to keep it in check. We've looked extensively at the rules that Interpol implemented in, last year, 2012. And they're good. On paper, they look good. They restrict the use of Interpol systems to certain specific reasons. They have a de minimis criterion, so you can't use them for very minor offences. 2 years if it's an accusation case, or a 6-month sentence if the person's already been sentenced. And in theory, the Constitution protects against inappropriate uses of Interpol systems by ensuring that it stays in line with human rights standards, and by excluding interventions in cases of a political character. And it all looks good on paper, but for us the problem is the way these rules are applied in practice. So I'm just going to go over a few of the key issues that we've identified and what we say needs to happen to correct them. As we've said, the real issue seems to be, and this has been raised by participants before me, that you get cases where a national authority recognises that the case is politically motivated, either because the person claims asylum and they say, we can see that you're being prosecuted for your political opinions and not really because you're doing something wrong, and so you can have asylum, we protect you. Or they receive a request for extradition based on the same offence that underlies the red notice, and they say, this is a politically motivated prosecution, so we're not extraditing you. And yet, Interpol considers itself allowed to retain the information on its files, placing the person at risk of further arrest. That, for us, isn't the correct interpretation of its obligations, or what should be its obligations. And we're worried, in a sense, about the use of this addendum system. So when Interpol is aware that someone's been granted asylum or had their extradition refused, often it won't remove the red notice, but will simply add a little note on the file to reflect the fact that there's been one of those decisions, and it still leaves the thing in place and leaves the person at risk of being arrested again. So we say they need to apply their rules in a manner more consistent with extradition law. Then the actual process of reviewing requests. So when a country says, we would like a red notice against this person, what does Interpol do when it decides yes or no? We've asked them lots of questions about this and discussed it with them, and the detail is still not there. We don't know enough to say concretely. We don't know how many people are doing this, what their training involves, what their backgrounds are, whether there are country experts and things like this. But what we have got some information. They've said, for instance, that they take into account United Nations Special Rapporteur reports. So, for instance, if there were, if Alice Bialyatsky got out of jail and they requested a red notice, they'd see that there were lots of reports about him, and so they would theoretically refuse the red notice. But that's in the specific case, and we don't know how it applies more generally. They also say that they'll go back to the country if they think there might be an issue and ask for more information about the allegation. But for us, there are signs in the cases we've seen that there are problems. In the case of Mr. Silayev that I've mentioned, as I say, he was accused of hooliganism, which is itself a really problematic offence because it involves, public expression issues. And the allegation that was included in this Interpol alert was extremely vague. It said that he, with his accomplices, convened a group of people, and that this group then went and demonstrated, and that some damage was done to a building. And there's strictly no specification of what he was supposed to have done wrong himself. And, this is, basic stuff. You need individual criminal liability, and it wasn't there. And that's a typical indication of persecution when there's a vague allegation against an activist like that. And yet, it doesn't seem that any further information was requested. And as well, the fact that the whole case was extremely well documented. There are dozens of reports. Amnesty International produced reports on the Kimki case documenting even that one of his alleged accomplices had been acquitted because there was no evidence against him. And we're not sure how much these things are being detected. So we want more clarity, and also clearly there needs to be a bit more done. Then keeping cases under review. I've used this example of a Belarusian, this isn't his real name because we had to protect his real identity, but he was arrested after being granted asylum in Lithuania. And the Italian authorities passed information to Interpol very, properly in the usual spirit. They said, Interpol, we've arrested this guy, and he tells us that he's a refugee, and here's a copy of his refugee travel document. And so Interpol knew that he had refugee status, and the Italian proceedings ended within a few days because it was clear that he was at risk of persecution. And yet he was arrested again 6 months later. And for us, it seems clear that in a case like that, Interpol should do what it can without it being too burdensome to follow up and find out what's happened. It could have asked the Italian authorities, well, what did you decide? And it presumably checked with the Lithuanian authorities that this asylum status was valid. So for us, there's a real question about what work Interpol is doing when it finds out about arrests to check the validity of information. And finally, this issue of iLink, it's in 2009, the old system was kind of radically changed. It used to be that a country submitted a request, Interpol did its own diligence, and then spread the request in the form of a red notice. Since this change took place, the information's uploaded directly in the form of a draft red notice with a little indication saying request being processed. And that's immediately available to all the other countries. And the General Secretariat then kind of puts its stamp of approval on the thing ex post. And for us, that was a source of concern, but we were to some extent encouraged that we're told that as a result of improvements since 2009, the information is reviewed very quickly, so within 24 hours. So it minimizes the chance of someone being arrested on the basis of information which hasn't even yet been reviewed by Interpol. But the problem is that whilst this information sits there for those 24 hours, there's countries all over the world can see it, and they can download it and take copies of it in their local files. And so even if Interpol says no and deletes the information from its databases, you've got potentially 190 local versions of this thing that remain, and that then the person has to go and get removed systematically, which, if you don't have lots of money and lots of lawyers and lots of perseverance, you're never going to manage to do. So that's a real concern. So we say it shouldn't be available in the interim unless it's an urgent case. And finally, when things go wrong, what happens? Well, currently, someone who's subject to an Interpol alert doesn't have access to a national court, to some extent for quite good reasons, because international organisations shouldn't be subject, to one country's jurisdiction, because it's not good for their independence. But it places a responsibility on the organisation. There's also no remedy in the issuing country. Like if I'm a refugee from Russia, I'm not realistically going to go to the Russian courts and say, please remove the red notice. I mean, you could try, but good luck. Also, it's been said by Interpol that you can rely on the country where you reside, or the country of your citizenship, if you're on good terms with your country, and get them to put pressure on Interpol to remove the red notice. We consider this inappropriate insofar as it's a diplomatic mechanism. It varies according to what your country's willing to do. It's not a the hallmark of a system governed by the rule of law. So it all puts pressure on this body called the Commission for the Control of Files. This is a panel of data protection experts, really, that was set up when France passed data protection laws in the 1970s. Interpol didn't want to be subject to them, and so it implemented, its own oversight mechanism for data protection matters. But over time, this body has come to play a really important role, because this is the only place that someone can turn to when they're suffering the impact of a red notice. And we have concerns about the way it operates. In the case of Petr Silayev, we addressed a 28-page application, which is available online if you want to read it. Maybe it just wasn't good enough, but we think it was okay. I mean, we made a big effort with it. It was full of asylum and extradition law arguments and things that we thought were relevant, and we provided lots of evidence. And we know that as a result of this application, a conversation took place between the CCF and the Russian authorities, but we weren't privy to it. We don't know what was said between them, what questions were asked, and what responses were given. The CCF then responded with a one-page letter, which included no reasoning at all, no explanation of how it approached the case, and stating explicitly that it had relied on information provided by Russia which hadn't been seen by us. And fundamentally, this poses an issue in terms of rights of defense. So that's really serious. And then the other big issue, as I say, is timing. Everyone we speak to in this field, all the lawyers who have experience working in these cases, all report to us, I've been waiting for X number of months. The highest I've heard of so far is 24 months in our own cases that we've made the applications in. There's one where I've been waiting for 15 months for an answer. And the reason is that the CCF has to have these discussions with the country of origin, and they seem to take a long time, and there's nothing stopping the country take too long. And so finally, the other issue with the CCF is simply the expertise. As I say, it's a data protection panel. They're very good at data protection stuff. They advise Interpol very well on data protection issues. But for us, the problem is that, we're dealing with asylum, extradition, criminal law, and there's no recognised asylum, criminal law or extradition judge or senior lawyer on the panel, so it's a bit worrying. And also, it doesn't have the power to issue binding decisions, which obviously, to some extent, compromises its independence. So we recommend the creation of a new panel, that operates more quickly, that doesn't rely on things that haven't been seen by the other side, that can issue binding, reasoned decisions, and that it should publish its decisions to engender confidence in the system. And there should be a possibility to challenge decisions. So I'm sorry to have gone over time a bit, but that's my piece on Interpol. If you want to email me, that's me there. Cheers.